Hello.
Hey,
Introduce yourself. What's your name?
J.R. Ewing.
Okay. Nice to have you here, obviously, on a Sunday. We have you for 1 hour. I will take up your full amount of time. Whenever you're done, just leave. Just leave. Don't have to even say goodbye.
Click.
Uh, so before we start, we're going to run through a bunch of stuff. So I'm going to try to go at a good pace. Before we start, of course, let me see if I got these in the right order. Picking a, and we're talking about some of what we're going to talk about is Supreme Court, amongst other things. Picking a Supreme Court justice is a lot like crossing a river. It's Roe versus Wade. Supreme Court is just a regular court with sour cream and diced tomatoes. And last but not least, did you know that the basketball court on top of the Supreme Court building is truly the highest court in the land?
Did not know that. Didn't even know there was a basketball court up there.
Yeah, there may not be. Anyway, very nice to have you. What I was going to do is do two quickies. I'll just do it as opposed to yapping about it. So I saw an article today about Boeing. Boeing apparently is going to get charged with fraud. And they've been offered a plea deal. The plea deal is they can admit, they could pay a fine, and then they could have somebody watching over them. Like they could have like a receiver or something like that, just kind of checking them out. Now, they were apparently given an opportunity to get their act in gear, but what happened is they probably actually threw a gear out of the plane. But actually what happened is in January, there was an Alaska airline flight, the door fell off. That's why they were under double secret probation. So the Justice Department deemed that wasn't a good thing. And so apparently they're going to have to decide whether to go to trial and risk a worse result or just say, we screwed up, let's make it better and whatever. Thought it was interesting since Boeing's such a big player in the United States.
So just so everyone knows, doors are not supposed to fall off the airplane.
That's true. Yeah, they apparently only missed 4 bolts.
Is that
whatever.
it? Just
yeah. If it's the 4 wrong ones, I guess
really 4 important ones, though.
That's right. Yeah, it's called the Frankenstein airplane, as it's known. So that's one. 2, Tesla. I'm going to briefly go over Tesla. So Tesla's interesting where it currently is in the legal standpoint. There is an action that was brought against Elon Musk to attack his pay package. There was litigation. In the end, the court decided the pay package would get thrown out. And even though the shareholders had affirmed the vote, the court said they weren't properly informed. There was conflicts of interest, etc. After that, the case proceeded, and now attorney's fees is at issue, and it's some humongous amount of attorney's fees.
Sure.
Billions sought and millions offered. Let's say that's the standard. And then what happened was, before the motion on the attorney's fees was heard, there was a meeting, a yearly annual meeting with Tesla, and they voted to ratify the same pay package. And after that, the pay package had been thrown out by the court in Delaware. After that, the attorneys for Tesla asked the court in Delaware to re-examine the proceedings in light of the ratification. The other side said no, because that ratification was subsequent and didn't apply to the first. And there was some letter that the judge sent out basically at some point in time and said, I'm not going to consider these motions that are pending to protect the judgment because, as far as I'm concerned, Tesla has acknowledged they're not going to try to circumvent the judgment. So that's a letter in the file. So Tesla now is filing a brief tomorrow about the ratification issue. On July 8th, there's a hearing as to the attorney's fees. And the end of July, there will be a hearing as to the ratification and what effect it might have on the litigation. That's a quick summary. Any questions, JR?
So it all comes down to the attorney's fees.
Attorney's fees on the ongoing case, but it really depends if the court wants to kind of change directions and say the ratification of the pay package by the shareholders is sufficient to reinstall Elon's pay package. So that's kind of, and there's 2 things going on. I know that in judges I've appeared in front of before, when they make those pronouncements, like I said in the letter, if you go against them, they're usually not very happy. But we don't know because, but we don't know in Delaware, because Delaware is an interesting condition. Like 40 or 45% of their income, state income, comes from corporate fees. And there's a concern that companies may leave because of situations like with Tesla. And will somebody at a higher level maybe knock on the door of the judge and explain this? Or is this judge out the door anyway to bigger and better things? We don't know. All those kind of play in, and I thought it was kind of an interesting scenario, and we'll see. And I talk about it at times. So next case, let's talk about Jarkesy. Are you familiar with that case?
A little bit.
I want you to talk, and so give me your take on that.
So, we talked about this back in July when we did the live stream. During or after oral arguments, the two-part oral argument. The case was about the Seventh Amendment right to a jury trial, and whether or not the SEC can choose between the administrative law judge or going into federal court. And there seemed to be no consistency between how they did that. And so Jarkesy, who went through the administrative court with an administrative law judge, was found guilty of fraud. Now, fraud, it's 10b-5. It's fraud under the Securities and Exchange Act of 1933, but fraud is a common law claim. And the way the Constitution is written, all cases, controversies, and common law claims need to be tried by an Article III court. Now, there's some exceptions to that, but the exceptions didn't apply here. And so Jarkesy made the argument that, look, the SEC is arbitrarily picking and choosing who goes to federal court and who goes in front of administrative law judge. And as the community's very well versed in this, going in front of administrative law judge or an arbitrator, you don't have the full breadth of rules and or federal rules of civil procedure and their subsequent discovery rules. You're not armed with those things under an administrative law judge. It's more like the wild, wild west. They pick and choose what they want to allow in and don't allow in.
Really?
Whereas under federal court, under a federal court, you have access to the full breadth of rules of civil procedure. And so Jarkesy was arguing that, look, they denied me of my right to a jury trial. And so the argument was that Article III mandates that common law claims, when they're seeking damages, which in this case the SEC was seeking civil penalties, by virtue of what the Constitution says, they should have been allowed to. They should have been offered a jury trial. And so that was the gist of Jarkesy's argument. Now, there were some other arguments there, but the court didn't need to address those because they found in favor of Jarkesy that he was offered or should have been offered the right to a jury trial because of the 10b-5 fraud claim is almost identical to the fraud common law claim. It's got the same elements. They look for the same things. And so he should have been in federal court. So that's my understanding. Now, you and I had a pre-conversation. I tend to think that they limited it to the SEC 10b-5 claims, but admittedly, I probably did not read the case with as fine-tooth comb as you did. So why don't you expand upon what we were talking about earlier?
Yeah, it's only 95 pages, so it's well worth the read. Anybody who can't sleep at night, 98. Okay. Anybody who can't sleep at night and needs an aid, 3 or 4 pages, you're done. So it's let me frame it in a different way. So it's the SEC's internal judicial process that was challenged. And part of the challenge was the SEC when it was, and by the way, Jarkesy was fined $300,000. So in my mind, I don't know Jarkesy, but he might be a scumbag for all I know. Maybe it's justified. He was fined $300K. Maybe that's like a disservice to the world that he got out of the fine. But is he getting out of the fine? Because probably not. Because before I go back to kind of talking about the SEC, what's going to probably happen is the case will go back down, he'll get a trial, and maybe he gets 750,000 against him. So it doesn't
it's a
necessarily,
crapshoot for him.
yeah, it doesn't necessarily mean for this guy that it ends well. It means for the concept, it might be good. And so with the SEC, it's because they're the investigator, the trier of fact, and the judge. And I think during the time of Jarkesy, there were 3 judges. That's all the SEC had.
And let's talk about the practical implications of what they said under the 10b5, 10b4 claims, because
No,
now they have to go in front of a federal judge. So the cases are going to have to be a lot tighter. They're not going to be able to go in and fly by the seat of their pants. They're going to have hard facts and hard evidence because they're going to be presenting it to a jury. It's going to be more costly. It's going to be more time consuming. And, whether that's right or wrong, I'm not saying, I don't know the answer to that, but the practical implications are that it's going to be a heavy lift for the SEC to do that.
yeah, you can imagine. Do you think it's probably they get a better shake in their own judicial system with their own judges, or
Right.
against Article 3 judges? Probably they think they get a better shake when it's their own judges. And all 3 of those guys now probably have more free time. I don't know what they'll do. But the idea, so what's the significance of that with the SEC? That means all their proceedings, and I believe it expands beyond just fraud, because it really says common law claims, and they define kind of reverse, because
Right.
there's a doctrine, I think a public benefit doctrine, which says, I don't really understand what it says, but ultimately what it says is that Congress can allocate certain functions to things other than Article 3 courts. And that's like immigration, customs, IRS, collections, admiralty law. None of those would apply. But in any case where there was money sought that was from a claim that existed, like a negligence claim, contract claim, conversion, it's almost any claim that would fit as a common law claim. So even though this was a 10b5, a securities fraud claim, I think you can, and I think we're going to, when we get to the Chevron doctrine, it's going to make a lot more sense. But I think it's much broader. I think it opens the door to all claims. And before we get to the Chevron doctrine, I kind of want to relate this to Alpine. So there are, I believe, 3 cases in this same, no, it's not I don't think it's the same circuit, but there are 3 cases involving FINRA where FINRA's judicial system is being challenged. And again, it's somebody like Jarkesy who's been fined or done something, probably a scumbag, but they got involved in the FINRA system. So FINRA, and JR and I were talking about this. So it's really interesting because FINRA is not the government, but they have immunity. But the SEC monitors and supervise them. So in effect, if they're required or they require arbitration, are they required to offer the same 7th Amendment jury trial because it's the government requiring and governing this agency? And I was thinking about if I was on FINRA, on one hand, I'd say we're not government, so we could contract for arbitration. We could do that. And then if I'm on, and I clamor about this all the time, so I'm just going to clamor about it one more time. I think like the solution to the problems that retail shareholders have is the fact that there is immunity, and that like agencies or SROs, self-regulatory organizations like FINRA, have immunity so that they don't have to, they don't have to respond to lawsuits brought against them. I could testify to that. They don't have to get involved in discovery. I could testify to that. And obviously, in my opinion, is they certainly could buy insurance if they think there's risk. So if they didn't have immunity and they thought they were going to get sued like everybody else on this planet, they buy insurance. But if they're not the government, they deserve no immunity. So taking that back to Jarkesy, will those cases that are kind of deciding the FINRA aspect, will those go up too? And what do you think will happen? That's directed at you, JR.
Well, it's hard to say. I mean, so so they're arguing under Alpine that they're not a state actor, yet they do all these things to suggest they are. They promulgate regulations, they write them, they send them up to the SEC, the commission, for approval. All the commission does is they either make comments or they approve them. So they have regulatory authority. They're also the final decision maker on some of their implementations. And we've seen that, the halt. They made the decision. They have a commission of 4 or 5 people, all of which have just recently come out thanks to the hard work Curtis did. They're all industry insiders. They probably all hold heavy positions in MMTLP. At least we suspect the brokerages that they work for hold those positions. So they're making decisions based on the regulations that they promulgated. So how are they not a state actor? Now, my own personal opinion is the SRO model, whether it's FINRA or the other, I think, half a dozen SROs that do similar work in different industries.
By the way, you know what SRO is also?
What's that?
Standing room only.
These organizations have found themselves above the law. They found themselves to be somewhat untouchable. That they are not constrained. They behave unconstrained. Then on paper, Gary, all this is oversaw by the SEC, but we know that's not the case. So something has to give with these organizations. They are somewhat, in my view, un-American. They're beholden to no one. They're all industry insiders. They're all patting themselves on the back and taking care of themselves. This is government cronyism run amok. That's what it's become. It might not have started off that way. It might have started off, being effective and being a good regulator. But what it's morphed into and what it's become is, in my view, unconstitutional.
All right, there you go. There you have it. Yeah, I just think simply that it's either government or non. It's government or non-government. If it's government, then you have a Seventh Amendment right to a jury trial.
That's right.
And if it's not government, then there's no immunity.
Yeah, the Supreme Court with these two decisions is there's a lot of arguments to be made that they're eroding they're eroding not only regulatory authority, but they're eroding the SRO model.
Yeah.
And these two decisions, I think, and forget about what MMTLP is going through. In and of itself, these two decisions are probably going to have the most long-term impact and be felt by the American people more so than probably the last 5 years worth of Supreme Court decisions.
Yeah. So Jarkesy is kind of like the specific, and the Loper case is kind of the general. And we're going to get to the general. We started with Jarkesy because we spoke about that, like, I don't know, 6 months ago when the oral argument was, and it was really related to Alpine in the way, and we still think so. But again, in my mind, I think some point in time, somebody's going to ask the court to draw the distinction between the right to jury trial versus immunity, and you can't have neither. It's going to be one or the other, because you can either be you have to be government or not government. It's going to be one or the other. And this Supreme Court is obviously not going to be super sympathetic to administrative agencies. I mean, it's obvious. So I think they'll all be under, and that was before the Chevron, right? Didn't you think it was before Chevron? Yeah. Before the Loper case, we thought
I didn't even realize. If we'd have known back then that Chevron was, we would have been talking about it, because Chevron's huge. Chevron is the seminal case in administrative law, and it's been that way since 1984. It's just a huge case. Any law student going into their second year of law school taking administrative law, that's the first thing you talk about is Chevron, the two-step analysis and Chevron deference.
Unless you're too old.
Yeah.
And they didn't have that. And by the way, Chevron, I don't like Chevron because the gas is really expensive. So I'm glad.
I didn't know how to spell it when I was in law school, and I still don't know how to spell it.
I know. All right. So we have kind of Jarkesy is kind of like the specific that says you have a Seventh Amendment right to a jury trial because it's a securities fraud common law claim for money, and that was the fine, the $300,000 fine. That was so it was a stretch. They stretched it. So when we talk about the claim was for money damages, that was a fine. So money damages might end up being interpreted pretty broadly also. Can't anticipate what that will be, and that probably will be a bunch of cases. Now, defining what a common law claim is for money, there'll probably be like a bunch of cases where maybe it has like money as an element, but it's really not for money, and is there, whatever. But it'll be interesting. But that's specific, and we think that there's a bunch of cases involving FINRA that may end up in front of the Supreme Court probably next year, where the Supreme Court starts to kind of limit the powers and abilities of FINRA and restricts their ability. Maybe at some point in time, I really do think it's at some point in time. At some point in time, the way arbitrations are administrated currently is going to be changed, and there will be more evidence of due process. That is not the current system, but we think it's on its way. So the Chevron case, because we've kind of alluded to that. So kind of give us a little background on that.
So I'm just going to read a small paragraph right from the court's opinion, because it really explains it. It's pretty straightforward. Our Chevron doctrine requires courts to use a two-step framework to interpret statutes administered by federal agencies. After determining that a case satisfies the various preconditions we have set forth Chevron to apply, a reviewing court must first assess, one, whether Congress has directly spoken to the precise question at issue, if and only if congressional intent is clear in the statute that Congress has passed. That is the end of the inquiry. So if the statute is very clear, spells out exactly what's supposed to happen, that's it. That's the interpretation the court has to use. But if the court determines that the statute is silent or ambiguous with respect to the specific issue at hand.
Now, can I stop you there? Since the court has to determine it, once they look into the question, you may be lost already. Right? Because they're already analyzing it. And if it's okay, they don't have to analyze it. It's only when has some ambiguity where they're most likely to have to analyze it.
And I'm going to get to that in a second. But if the court determines that the statute is silent or ambiguous with respect to the specific issue at hand, the court must, on the second step of Chevron, defer to the agency's interpretation. So even if the court looks at it and says, yes, there's ambiguity in that specific statute or that specific provision, the court has to defer to the agency's interpretation if that interpretation is permissible under the law. And that's it. The analysis is over. What this case did was say, no more. Article 3 courts are charged with interpreting the laws. Therefore, we're not showing agencies any deference anymore in their statutory interpretation. The court is now going to review the statute, and it's going to apply its interpretation of the statute using the standardized statutory construction methods that court use. So, a couple of problems that I foresee, and then I'll get to some comments. Problem number one is you're no longer deferring to the agency on an statutory interpretation. Now, everybody's like, "Ooh, government's no longer in our face." But here's the practical implications of that. We're not talking about, 10b-5 under the SEC. We're talking about everyday administrative things that the government does to implement rules and regulations. Probably 90% of those rules and regulations are there for the benefit of society, to keep us safe at work, keep us safe in our cars, keep us safe on airplanes. Think about just the safety aspect that all these federal agencies do. And so now what this case did was it said, okay, we would normally defer to the agency's interpretation of the statute, but no more. Now we're going to let 94 federal judges review the statute, and if they don't like the agency's interpretation of the statute, they're going to come up with their own. So they've become ad hoc policymakers. This is my belief. I tend to think that that's not good. And it's not good for a couple of reasons. Most importantly, because like I said, you've got 94 federal judges out there. It's going to encourage two things. It's going to encourage confusion among the same statute, potentially anywhere between 4 to 5 different federal court districts could be listening to the same issue and rule 4 to 5 different ways based on the political affiliation of the judge, based on the judge's common sense, practical analysis of the law and statutory construction. The next thing it's going to do is it's going to encourage forum shopping, because if it's a federal law, as long as they have, as long as the federal court has personal and subject matter jurisdiction's out the door. We know they do because it's federal law. So as long as that particular federal court has personal jurisdiction over the entity the entity involved, now we can forum shop. Oh, Judge Jigger Shop down there, that was all I could find. Judge Jigger, he's anti-government, so we know what he's going to say, so we're going to him. Or Judge Bush over here, we're going to him because he's pro-government, so we'll know he's on our side. So those are, I think, two big negative outcomes. The big one really being multiple decisions.
All right, so I'm going to work the other way.
You're going to cut me off.
First of all, I'm going to cut him off. And first of all, like I told JR, the forum shops are in Vegas at Caesars. So I don't know what he's talking about, the forum shopping. I don't know any idea what he's talking about. The point that, and we discussed this a little bit, the point that this case deals with is where the law itself is inept. It doesn't give enough guidance and restriction and definition. So it would be like, for example, the grant from Congress to the SEC, go regulate the securities market. It's something like that. And there is something like that. And that, they say, that's not sufficient. That's not sufficient detail guidance to allow the agency thereafter to determine what's right and what's wrong. If Congress doesn't specifically lay it out, they still retain the right to demonstrate and to announce what the intention is of the law and to deal with it. And my view is what this does mostly, and the biggest positive benefit, is it will require legislatures to do a much better job of drafting laws and regulations, because they know that anything they draft might come back to them. They'd rather not deal with this stuff. They have the agencies to deal with the administration of whatever agency is, and they will be forced to do a better job.
Right. Well, it's going to force Congress to write laws that have a certain level of specificity to them now. Now knowing that the agency isn't going to be allowed to interpret it. Well, let me take a step back. The agency is going to be allowed to interpret it. It's whether or not the court buys their interpretation of the law. So on some level, I think you'll start to see a little bit more controversy among legislation that normally wouldn't be controversial, because now the FDA is involved. And, we don't like the FDA. So we got to make sure we lock them in a box when it comes to their regulatory authority. Well, that can be controversial. Even the FAA, those rules and regulations can be controversial if you're locking them in a box or expanding them. So I think you're going to see more of these agency rules or agency statutory authority issues really hamstring Congress now, because now they've got to write laws with a certain level of specificity.
I think it will. Yeah, I think it will cause the courts to be more involved in these, because if you're challenged with an administrative ruling, you're going to go for it, right? You're going to say
Sure.
they didn't have the right to make that call. That was a congressional call. You're just going to throw it out. You're going to cite the case, and there you go. Besides whatever else you got going. But again, it's up to Congress to write good laws. And right. We know that sometimes they're this is part of the problem. Sometimes they may be influenced by groups that have a particular desire. And so the law may not reflect how it should to protect the class of people it's supposed to protect.
Sure.
So maybe
Sure.
now we'll get a little less of that, especially if it becomes heavily scrutinized and the legislatures are, embarrassed by not having done a appropriate job. But the point is, it kind of, if we look at it backwards, it kind of permitted the inquiry in Jarkesy, right? So the court looked to decide what kind of judicial system was intended or should be provided. And it went back and analyzed the situation, but that was before Chevron. If the situation were today, I think it's a slam dunk. They would go ahead and do it and provide more scrutiny. The decision may not be any different, but the ability to get to that decision is different. And again, I expect that eventually it's going to affect all agencies, all federal agencies, and the SROs, it will impact. Just don't know what that impact will be. I don't know if they'll be treated more government or less government. And if they're treated more like government, they might have certain rights and abilities. And if they're treated less like government, they will have less rights and abilities. And, for us, for those out there who are MMTLP or the like fans, we would like, obviously, to have a better chance to have access to materials that agencies have. And again, maybe indirectly, this is a way of opening that up also.
Right. Well, I mean, you and I talked about this right from day one. I've never believed that they're immune under the Administrative Procedures Act, and I still don't. And I think what Looper does is it gives another.
Looper, by the way, that's the Chevron doctrine.
Looper's the case that overturned Chevron. I think what Looper does is it opens the door to a stronger argument against FINRA. When all this went down, I started working on some issues under the Administrative Procedures Act. But one of the things that I was always concerned with was the deference that they would be shown in the decision-making process that the decision-making process under the.
Is your name Joe Biden? Is that Joe Biden there?
And I was going to say the S1 halt, but I knew that wasn't right, and I was trying to find the U3 halt. So they would have been shown deference under the U3 halt because of Chevron. And now they don't have that deference anymore. Now a court can look at it and say, yeah, we don't think this settlement issue was permissible or reasonable.
So yeah, I'm sorry. Yeah, so
the bottom line.
The bottom line is that agencies will have less power in the future, and their decisions will be more at risk because they can be challenged on more grounds. And for those of us that haven't been fond of the way agencies have processed information or made decisions, I think it's a good decision. And again, if we can get Congress to do a better job at writing the laws, that would be helpful too. I'm going to ask you a question off the wall. We didn't talk about it before. I just wanted to cite in the Supreme Court opinion in Jarkesy, and I found it's just one sentence, but I thought, wow, if I'm in a case, I'm going to use this at some future point. The sentence says, Congress cannot conjure away the Seventh Amendment by mandating that traditional legal claims be taken to an administrative tribunal. That's part of the opinion. To me, I would cite that in any federal case where I was challenging the inability to get a jury trial. If I was challenging arbitration, anything like that, I'm citing that one sentence in that opinion.
And again, we talked about this prior to the show. We think that Jarkesy now opens the door to make an argument that FINRA is a state actor and that they're denying people their right to an Article III court and a jury trial by mandating that their 105 members have the arbitration clause in their terms of service. They're basically they're constructively taking away your right to a jury trial because no broker is going to take you if you don't agree to their terms of service.
And by the way, just as another example, if you're a Tesla fan, the NHT, the National Highway Transportation Safety Association or Board, whatever it's called, they are the ones who are going to decide upon full self-driving and Tesla. And so from Tesla's perspective, in light of the Chevron deference decision, those laws, which don't exist yet, are going to have to be super on the money, or the National Highway Transportation Agency is going to be able to do diddly, because whatever they decide is not going to be upheld, because it's not going to reflect at least an understandable law. So I think, and I agree, again, the NHTSA is just another agency that probably got lost a bit of power. I wonder if they're going to lose some funding also as a result. Don't know. It'd be interesting if they have less power.
I mean, I can understand, the reaction that we want less government, bureaucrats shouldn't be making decisions, but those are all the what's the word I'm looking for? Those are all the controversial agencies that are out there. The everyday agencies, National Transportation Safety Board, FAA, OSHA. These are agencies that are making decisions based on ambiguous statutes to keep people safe. Is it a good idea that we should now be putting that interpretation back in a federal judge hand? I don't know.
Well, I know, but wouldn't you say like Boeing is kind of like waiting for like another door to fall off? Don't you think like whoever is regulating them has been a little too patient?
But on some of that stuff, it behooves the corporation that's being regulated. I mean, the airline industry needs to be well, let me take a step back. The airline industry is an industry that needs to be somewhat self-regulated. And I say that because airlines aren't going to operate shitty intentionally. They're not going to put shoddy airplanes out there intentionally, because it's only going to take one or two airplanes to crash because they didn't follow their own safety protocols, and they're going to be out of business.
Yeah, I'm gonna call you on that.
They're not going to exist anymore.
But in this case, there were whistleblowers that came out and said that very thing. They were like using used parts in some place, and there were a bunch of inspections. So I don't think this is nonsense. I think they were actually not up to standard. They obviously had a bunch of things that happened. There's one crash that killed, I think, 367 people. But
Right.
There was a lot of this is kind of thing. So probably most times when you fly, 99.9% of the time, there's no problem. But that 1/10%, if you're on that plane, that's the wrong plane to be on. And if you're the problem with Boeing is it's a monopoly. There's not like there's competition in the United States. There's no competition in the United States. So there's Airbus is not in the United States.
I know they're not in the United States, but they have competition.
Yeah, but at one point in time, Boeing was like the pride and joy of America. And now
they make shitty airplanes.
It's almost listen, because I was going to
fucking door fall off.
Well, I would say Boeing to me is the equivalent of that debate, in my opinion. So quickly, as a little bit of a twist, I didn't tell you I was going to do this, but did you happen to watch the debate on whenever it was, Thursday night? Okay. I generally do not. I do not. I did. This is rare. I did. I was just interested, and I listened to most of it, so I didn't watch all of it, and I was amazed. I thought it was, and I've gotten like people from other parts of the world who've communicated with me, and they were incredibly moved by that. I thought it was like, and again, I'm from California, so you can imagine where my politics lie. I was not going to vote for either of these. Honestly, before the debate, I had decided not to vote for any of these people. I'm a protest vote here. I want there to be a lot more votes for other offices other than president, to show that people are dissatisfied. Because in California, obviously the Democrat's going to win anyway, so it's not going to really make a difference. But I really was saddened by what I saw. I thought it was an embarrassment. By the way, it's not like the other gentleman had a great night either. So I'm not giving him props, but when you're playing against somebody else who looks diminished, that was really sad. And what concerned me more was the next day he seemed fine. So to me, that is weird. And that was more concerning. By the way, that was more concerning. The contrast from one day to the next, that concerned me, because that sounded like somebody maybe is like, bouncing back and forth, some good days, some bad days. And it really concerned me. And our adversaries probably watched it too and would take that into account. So I thought that was shocking.
So I read about them. I watched a couple of clips. I think my biggest issue is, number one, this is the best we can do, which is sad that we have to rely on two old white guys that are in their 70s, to run for president.
80s, once in the 80s.
80s, 70s. It doesn't matter. They're old. Neither one of them are physically fit to be in the office. I'm sorry. I don't care if you're pro-Trump. I don't care if you're pro-Biden. Biden pretty much looks like they wheeled him out, stood him up on the chair, pushed him. Trump is, Trump's not all there either, as far as I'm concerned. But the fact that this is the best we can do is, it's pretty sad. Now, we have no young leaders in this country that can step up, that we've got to put the former president up there who's got name recognition all over the world. And we got to put Biden up there because, he's a trusted member of the Democratic Party and he's a sitting president. The guy's not going to make it another 4 years.
Yeah, no, I agree. I mean, if I was going to vote, this is my personal view. If I decided to vote for Biden, I would presume that his vice president would be in office at some point in time during his second term. Might be day one.
I would agree.
I don't want. Anyway, I found it really disturbing that that's what we had, and there's nothing good that came out. I thought it was sad. And again, I noted the next day he was fine, or seemingly fine, but it's not fine for our country. But I was going to say is, I bet you some of these people out there have GTII, right? So amazingly enough, there was one person that thought that Joe Biden did a fantastic job at that particular performance. You know what it was? This is a joke, by the way. Do you know who it was?
No, I'm sorry. I was reading somebody's comments.
The only one who thought
it's not racist to call them old white guys. It's reality.
The only one who did well, the only one who thought Biden did well at the debate was David Reichman. That's a joke. That's a joke. That's a joke. Also, I think he's older, or is about the same age. Anyway, I thought it was really. I never watch. I watched just for that reason. I wanted to see how he performed, and I was disturbed by the performance. Anyway, just thought a little twist on that. We got a couple more cases to go through. I wanted to talk to you about it, and some of these you may not know about. We talked about it briefly, but one was the Purdue Pharma case. So that's the case where Purdue Pharma and the Sackler family, appropriately named, they sold opioids to everybody and their dog. And a lot of people died as a result from opioid abuse. And these guys, this company, made billions of dollars. So eventually there were some lawsuits that went, and the company Purdue Pharma filed a bankruptcy. And within the bankruptcy, there was a plan prepared where there was a pool of money that was put together to pay the victims' families, I think, of some of the victims. And they raised, I think, from the Sackler family, something on the order of $6 billion that was going to be paid over time. Anyway, it got taken up to the Supreme Court, and the Supreme Court threw out the settlement. And they basically said the Sackler family were not the subject of the bankruptcy. It wasn't their bankruptcy. And all the claimants who had been harmed didn't have a chance to approve of the settlement as a result. And as a result, the settlement's out. Now, the decision was 5-4, so it wasn't on ideological grounds. Even I think it was Gorsuch. I think Gorsuch said he was concerned if they'd be able to get enough money together in the future to deal with the victims. In other words, if the Sacklers had to voluntarily pay, they may not, and they
Right.
may not get as big a pool together. But anyway, I thought it was interesting, and I thought that there's no family more deserving of being responsible for losing all their money than these scumbags, in my opinion. They have enough money. I understand the questions, but I think the victims should be able to go after these guys for every penny they get. And if these guys have to file personal bankruptcy, so be it. Let their money be accessible for everybody. I thought so.
Right.
Anyway, I thought that was an interesting case that happened last week. And also last week, what happened was uh, there's a case called Grants Pass. It's an Oregon campsite, and there was public. You could stay over in public, and you could put a tent up and that kind of stuff. And I guess at some point in time, they decided to enforce rules against homeless being able to stay there. And the case went up to the Supreme Court. Supreme Court found there's no violation of the Eighth Amendment, which is against cruel and unusual punishment if you
Right.
remove somebody. So it may be the case that cities now who didn't do this might start removing home. I mean, at LA and probably every warm weather city.
Seattle's got a
Yeah,
huge homeless
yeah,
population.
along the West Coast, there's a ton. Now there may be an ideological reason not to do something, but even like in places like in San Francisco, people are very frustrated and have lost patience. And it may not be, I don't live there. I live in the southern part of the state. So it may be that things are overplayed and, and you could concentrate on certain things. If there's a national, I've experienced this. If there's like some event that happens and you watch the news, it appears like that event is happening over the entirety of the location when usually it's spot. But San Francisco has gotten a lot of bad press,
Oh
and
yeah.
they have a terrible homeless program. And if they have the ability to remove homeless from the street, hopefully find them an alternative place to live or an alternative style of life to live. Because I don't like the fact that there's homeless, period. It's, again, another one of those things. It's an embarrassment to the country. Why in the first place, why do we have so many homeless people? There are reasons, and those
Mhm.
reasons have to be dealt with. But it also shouldn't be allowed for those people to perhaps pass disease. And I was thinking about this recently. There was protests at various colleges, and people stayed on the college campuses for sometimes days. They didn't have adequate sanitation or bathrooms like that.
Right.
That's kind of the issue. You don't have that. And as a result, and kind of one of my reasons I oppose those type of encampments is because it does create health problems and health situations. And at least perhaps they'll be motivated to provide more housing. I know there's a foundation in Los Angeles called the Weingart Foundation, and they have in a part of downtown, they have bought a bunch of old high rises, refurbished them, and now are providing housing to homeless or others that aren't able to find any place to stay. And I find that's a useful use of those old buildings. But again, this was an interesting case because it allows cities a lot more latitude to deal with their own problems. And
Right.
I'm sure there will be cities that do that. I hope they don't start like dumping. There was times where they'll put people on a bus, they'll drive them somewhere. Usually it's with immigrants, right? It happened with immigrants at the border. Like it was Texas, I think, to New York. I think that was
Yeah.
the trek. Now
Yeah.
now I hope it's not like, California gets a couple buses full of homeless and sends it to Florida. Because I hope they don't discard those people. Because, again, those are people with issues and has to be dealt with.
Well, I think you're going to see a lot of downtown businesses owners start to put pressure on their elected city officials to do something extreme like that. I just remember when I went to Seattle, and I don't even remember where it was going. We were in an Uber and we turned the corner and there was literally a tent city. There was this big, massive triangle park that three different highways or roadways converged in downtown Seattle. And they kind of all came to this point and they're right there. You know, you're in your lane and you look over and there are just tents, tents upon tents upon tents, cardboard boxes. They just had a terrible homeless problem when we were there. I want to say 2015, 2016. I'd never
Yeah.
seen anything like it. And I've been to almost every major metropolitan area in the country, and I'd never seen anything like that.
Yeah, my wife and I were there, I think in 2022, and we went from downtown to Pike's Market. That
Mm-hmm.
was kind of what the area you're describing. And I
Yeah.
remember we had a tour guide, whatever. And I remember like we're halfway there and there was an alley and it's daytime, you know, it's like, let's say 10 o'clock in the morning.
Mm-hmm.
And some guy's shooting up heroin, you know, like 20 feet away
Oh
from us.
yeah.
It wasn't like a big deal, but it was really disturbing. It was disturbing that it was, you know, that out of control.
Oh,
And
it was bad.
and what had happened to downtown, you know, what happened. I didn't have that much experience, but it's really terrible. And again, so maybe this decision is in part, you know, a response to the justices seeing pictures of the homeless problem in various localities in the country. And you know, there's not a great solution. Bless you.
Excuse me. Sorry
Bless
about
you.
that.
There's not a great solution, but at least this gives the cities some discretion to do some stuff. So I think it's helpful. There was one more case that might have relevance. There's an immunity case tomorrow that's going to be decided involving Trump, which is a big case. And it's the last case for a reason, by the way. They're out the door. There was also a case,
Yeah,
right?
no shit.
Literally. There's also a case that was decided about the January 6th. One of the defendants, I think, who was faced with a charge for obstruction of justice. And the court ruled that I don't remember the exact ruling, but they basically said that charge did not support the crime. The facts of the charge did not support the crime. And they said specifically that if you look at the legislative history, it really refers to documents cases. And they were trying to use it in a different way.
Right.
So they threw out the conviction. They probably sent it back for a retrial or a decision whether there's going to be a prosecution. And then people were asking how that affects, or if that's going to affect the Trump case. I don't know. You know, could it affect the documents case? I don't know. Could it affect the January 6th case? I guess if there's an obstruction charge, if that's amongst the charges, then probably would. I would think if there's an obstruction charge that's not based upon documents, that this case would have value, precedential value, literally and figuratively, and that charge might be tossed out. But my guess is it's probably not the only charge, my guess. And this particular case was only on the obstruction of justice. It was just that. So
yeah, that's all new to me. All I looked at was Jarkesy and Chevron.
yeah, I just kind of got to get. It was a busy week. My son.
Yeah, well, it's the last week.
Yeah, my son was helping me. He was kind of keeping me alert to what was coming out. He had an interest in a different kind of case. Yeah, it was the end of the term. We kind of talked about it. You know, it's funny when we did Jarkesy 6 months ago, whatever. We said it could be the end of June, and here it was. And it was a long opinion, and I think there were multiple opinions. So they were thoughtful about it, and probably they knew Chevron was coming out too. So there may have been a bunch of cases involving administrative. You know, if you look back at this term, I bet you every administrative law case that was decided was probably impacted by the Chevron case. And they may have, you know, when they distribute, although I've never been there, but I have to believe when they make a decision which cases they're going to hear and they do some kind of preliminary look, they do a preliminary look. So they may have a decision without having an opinion. This is how we're going to work it. So perhaps they knew that, and every administrative case that they decided was with that in mind, that they
Right.
were eventually going to do it. So that's interesting. And it's as time goes on, perhaps you could figure out what those other administrative cases are, because I'm certainly not. I'm just
Yeah,
kidding.
it was definitely an interesting. I mean, those are two big cases, that have broad implications on administrative agencies. There's no two ways about it.
Yeah.
So,
Yeah.
I don't think the full effects are going to be understood at least for another, 5 to 10 years when the backlog, I could be wrong, but when the backlog starts happening in federal court, you start getting all these conflicting federal judges with different decisions on the same statutory provision.
Yeah.
So
Agreed. Anything else you want to add? We did it under
no,
an hour, by the way, 55 minutes.
oh, hey,
So, yeah. So tomorrow, if things work out, I'll have another live stream. I will certainly let people know when that time comes. And I'm sure it will be an interesting live stream if it does occur tomorrow. If it doesn't happen tomorrow, it'll happen Tuesday. But I'm hoping for it to be tomorrow. So I'll leave it vague like that, so the Chevron doctrine will kick in and the law will get tossed out. Anyway, thank you very much, JR, for your input. It was very thoughtful. Anybody out there who couldn't understand either of us or whatever, thought it was nonsense, please comment and please share. And if there's any comment that requires a response, I'll try to give you a coherent one, although that's not always possible. JR is usually good at that, but sometimes mine don't always ring like that. But anyway, everybody who watched, appreciate it. Hopefully it was informative. And there were a lot of cases at the end of the term. It's interesting to see there aren't that many cases that the Supreme Court decides in a term. I'm sure there was way less than 50 cases for the whole term. And that's not a lot when you think about it. Because there's a lot of law in the United States. So 50 cases is really not a lot when you're considering it. Yeah.
No.
But I'm sure they work hard. I'm sure they do a great job. And hopefully they will continue that in the future. And hopefully the ethics rules that have been imparted, I think this year, are respected and helpful, in my opinion. So anything else?
All right, everybody.
Saying goodbye?
I'm done.
Anyway, thanks again. Thanks for your time. Thanks everybody out there watching. Everybody have a great day. And again, I'll let you know about tomorrow. Be well, everybody.
Right,
take care. And again, thanks for your time, everybody.
Yep. Bye.